Also have a rapporteur, which is MS Fabriani Sabatira, who happens to be an intern at ITLOS in Hamburg. So welcome to all of you. Before I hand over the mic, just some basic ground rule. We have about 1 hour, 30 minutes ahead of us. If we can just map out and have 20 minutes of presentation each. I'm humongously averse to applying the guillotine, but I have a bell. So I would be ruthless at the end of the 15 minutes. I'll probably ring that and urge you to wrap up in the next 5 minutes. But you have enormous flexibility in 20 minutes. Then we'll throw the floor open for a Q&A. And may I urge all of you, notwithstanding that this is the post-lunch session, please make this as engaging and interactive as possible. With this, I will now invite Dr. Angeles Jimenez to please come forward. If you wish, you could do that while seated, or the floor is yours. Thank you.
Okay, I will wear my glasses so I can see the audience. So I would like to start thanking the organizers for this wonderful event here in Delhi. It's really a pleasure to me to be here attending the 48th Annual Conference on Ocean Law and Policy. And today I want to take you through the story of a rather unusual legal mechanism in the law of the sea, the statement of understanding concerning a specific method to be used in establishing the outer edge of the continental margin, better known as the Bengal Rule or the abbreviation Statement of Understanding, or SOU. I will refer to it using any of these three. And as you may know, states can extend their continental shelves provided that they demonstrate that there is a natural prolongation beyond 200 nautical miles. And this is usually done invoking Article 76 of UNCLOS. But there is an alternative, and this is my talk about how this mechanism emerged, how it has been applied by state, how it has been interpreted so far by the Commission on the Limits of the Continental Shelf, and why it continues to raise difficult questions about equity, geography, and the role of international institutions. I should be, sorry. Just once. Okay, it's just here, no? Enter. Okay, it wasn't working. So sorry. So here is how I have structured my remarks. Thank you so much. I will begin with the origins of the Bengal Rule, which go back to Sri Lanka's intervention during the third conference on the law of the sea. I will then review its application in practice, looking at cases from Myanmar, Sri Lanka, Kenya, and Spain. Next, I will move to the interpretative challenges, the way the CLCS has tried to operationalize the rule. I will highlight certain uncertainties that continue to cloud its use. I will point to emerging trends and questions, and I will close with some conclusions on where we stand today. So the origins of the Statement of Understanding are rooted in inequity. During the negotiations of the third conference on the law of the sea, Sri Lanka pointed out a difficulty, this problem. Article 76, paragraph 4 of UNCLOS allows states to establish the outer edge of the continental margin using two formulas, the so-called Hedberg formula based on distance from the foot of slope and the Gardner's formula based on sediment thickness. But in the Bay of Bengal, this produced an unfair outcome. This region is home to the Bengal fan, a massive accumulation of sediment carried by rivers like the Ganges, the Brahmaputra, stretching hundreds of kilometers seaward. And yet, the foot of slope is unusually close to the coast. So in this case, if the standard Article 76 formulas were applied, more than half of the continental margin would be excluded. So Sri Lanka argued that this not reflect the natural prolongation principle for this specific case because it would lose its rights because of its unique geological setting. The solution was a compromise. It is an exception, it is an alternative which is not placed in the main text of UNCLOS, but in the final act as an annex. So this is how it looks. This is the Bengal rule of the Statement of Understanding. It's only 5 paragraphs that got that name from the 5th paragraph because there is a specific, I know it's too small here, but there is a specific reference to the southern part, to the state in the southern part of the Bay of Bengal. So the idea was to allow the state in the southern part of the Bay of Bengal, with shelves that are narrow and sediment that are very thick, to draw other limits using a modified sediment thickness formula. So essentially, instead of relying strictly on the foot of the slope, this state will be allowed to establish fixed points where sediments are at least 1 kilometer thick, and then they will connect those points with straight line no longer than 60 nautical miles. So this is, the Statement of Understanding was recognized as it is a recognition that we have to balance law and science, and we have to recognize certain geological settings that might be different from the rest. So this was the genesis. It was finding a solution for a particular regional problem, but as we will see, the story didn't end there. So let's review the state practice. They are in chronological order according to the date of submitting the application for extension, the claim for extension to the CLCS. So I will start with Myanmar. Myanmar was the pioneer. In 2008, it submitted a claim for an extended continental shelf in the Bay of Bengal of the Rakhine continental margin, and it invoked both Article 76 and some sediment points, according to Article 76, and the Statement of Understanding. But Bangladesh objected, arguing that this area was part also of its natural prolongation. And this dispute reached the International Tribunal for the Law of the Sea, which in 2012 delivered the landmark judgment for the delimitation in the Bay of Bengal, delimitation of continental shelf, and first delimitation of the extended continental shelf. To this day, the Commission on the Limits of the Continental Shelf has not proceeded with this submission because the objection remains. So this showed that there is a structural limitation, and even when science supports a claim, a political dispute may freeze the process entirely. The second notable case is the one of Kenya, and we may say that this is almost a revolutionary one, because if we think about it, this is far from the Bay of Bengal. As I mentioned before, the 5th paragraph of the rule makes a specific reference to the state in the southern part of the Bay of Bengal, and this is almost 3 miles away from the bay. But Kenya invoked the Bengal rule, and its argument was quite simple. The rule is not geographically limited. There is no restriction. According to Kenya, inequity is inequity wherever it occurs. So it applied the condition, it will check if the conditions are met, and in case the conditions are met and the application of Article 76 will lead to an inequity, they will be entitled to apply the Statement of Understanding. The Commission on the Limit accepted this reasoning and validated the submission of Kenya in 2023 with issuing the recommendations that the other limits of Kenya are based on the Statement of Understanding. So this was a watershed moment because the Statement of Understanding escaped the Bay of Bengal and became a potential global tool. Then there is a case of Sri Lanka, of course. This was the main addressee of the rule. And in 2009, it submitted its claim based on the Statement of Understanding. Geologically, Sri Lanka is the textbook case. It has a narrow shelf, a steep slope, and a broad rise. But Sri Lanka's submission overlapped with the one of India, Myanmar, Maldives, and Bangladesh. And despite consultations, in 2022, India objected Sri Lanka's submission, considering that it could prejudice its rights in the Bay of Bengal. So it is ironic that the state for which the rule was originally crafted has yet to benefit from it. And finally, the case of Spain. In its original submission in 2009, Spain submitted an application for this part in the north. It is that corner of the Iberian Peninsula called Galicia, and they invoked the Article 76. But in 2024, the submission was amended, and Spain was following a hybrid approach. It was invoking Article 76 for the part to the west of Galicia, and it was invoking the Statement of Understanding to the north, to that part that belongs to the Bay of Biscay. So the CLCS has yet to issue recommendations in this case, but it seems that it is tentatively approving or accepting this hybrid approach. So together, these cases show how a regional fix has evolved into a flexible tool, a flexible instrument with a broader scope. And this brings us to interpretation. We saw the Statement of Understanding. It is 5 paragraphs long. It doesn't provide any detailed guidance. It is simply a set out a handful of criteria that we will see in the next slide. But it is the Commission on the Limit of the Continental Shelf that is interpreting it. The Commission, it is a technical body. It is not a legal one. It cannot legislate. It cannot make binding interpretations, legal interpretations. But the Commission is preparing guidelines on this. We have guidelines, the scientific and technical guidelines for Article 76 that were published in 1999. And it is working now in the guidelines for the Statement of Understanding. So through its recommendations, the Commission is effectively shaping the way the Statement of Understanding is applied. We have seen the case of Kenya. The Commission allowed Kenya to draw its outer limit based on the Statement of Understanding, even if it is not part of the Bay of Bengal. The same with the hybrid approach. Accepting or not, it is in the hands of the Commission on the limits. So in practice, the Commission is building, let's say, case law. It's not case law itself, but to say so, without having the authority to do so. These are the criteria to apply the Statement of Understanding. So the first one will be that the 200-meter isobath, that line connecting point at the same depth, must occur on average within 20 nautical miles from the baseline. So it is very close, like this depth is very close to the coast. Then the greater proportion of sedimentary rocks must lie beneath the rise. The average sediment thickness, so we need to draw this, we have to calculate the thickness and must exceed 3.5 kilometers. More than half of the margin will be excluded under normal formulas, and this is that inequity that Sri Lanka was referring to. And the outer edge might be drawn, drawing these straight lines 60 miles apart. So with the practice come the uncertainties. And as a member of a delegation trying to apply the Statement of Understanding, we are facing several challenges that I would like to share with you. So the first, I will go one by one on these ones. The first one is that the Commission was questioning this dual approach, the possibility of applying both Article 76, invoking Article 76 and the Statement of Understanding in a given submission. And it seems it has accepted it. At least in our case, it said yes, but we didn't get an explanation. So it might have created a precedent, but without clarifying how they reached those conclusions. So that will be an uncertainty for future possibilities of application of the Statement of Understanding. The second one, and the most important one for me, is the lateral extent. So when you are to apply the Statement of Understanding, there is a need to draw a polygon. So you draw a polygon to check if it complies with the criteria that I just saw before. And the seaward and the landward limit of those polygons are clear. But the lateral extent, those lateral limits are not that clear. We don't have guidance on how to calculate those lateral limits. So the Commission is saying, rely on political boundaries, rely on agreements. And in the absence of agreement, you can apply equidistance. So, okay, seems to be a logic reasoning. We don't have the legal basis for this because we are here talking about science, but at the same time we are bringing legal rules. But it seems that it might be a solution, like how to draw this polygon. But then we have the case of Kenya. So Kenya, as I mentioned before, 2023, they got these recommendations. Seaward and landward limits are clear. The limit to the south is clear, that's S2, because it's the maritime boundary between Kenya and Tanzania. But the limit to the north, this S1, is just an east-west line that was drawn, I won't say randomly because it's parallel to S2, but this ignores completely the judgment of the ICJ, the line that was drawn by the International Court of Justice in 2021. So we have here technical recommendations that don't align with a judicial decision. So this might be problematic, because the line here is blurred between science and law. We have the Commission is telling us to rely on political agreements, but then when we have a judgment, and a binding judgment, they are not following it. So this Kenya case may cause more problems in the future. Another uncertainty will be the problem of scale. The Commission says you need to draw a polygon, but a polygon is not necessarily a rectangle. There are polygons with many different shapes. And the CLCS tends to interpret the polygon as a rectangle, and this oversimplifies the coastal shapes. So this might be technically convenient. It will make things easier for calculations, but it strips away the natural curvature and the unique the uniqueness of coastal geography. So there should be a different rule for rectilinear coast and bay-type coast, but the Commission is always telling the state to draw a rectangle. And the final one is the Article 76 maximum permissible line. We have a paradox here because we have to rely on Article 76 even when we are trying to replace it. So to apply the statement of understanding, one must first define Article 76 maximum permissible line. You still have to make all calculation for Hedberg and Gardiner formulas to draw this maximum permissible line, and then the SOU uses Article 76 as the basis for avoiding Article 76. And not only that, it's apart from, okay. we apply Article 76 only to replace 76.4. There is nothing in the Bengal rule to say that the rest of provisions should be applied. But the Commission is saying you still have to apply 76.5 for the constraint line. You still have to prove the test of opportuneness. So that is, that's why I said there is a paradox here. So what trends can we see here? First, there has been a clear expansion of beyond the Bay of Bengal. From Kenya to Spain, they are finding creative ways to use the statement of understanding. There is increased legal creativity. Kenya's submission, of course, going beyond the Bay of Bengal. So we may see more states experimenting with the rule in the coming years. And then the CLCS, as I mentioned before, is preparing these guidelines. But again, the authority of the CLCS is technical, it is not legal. So this leaves open the question that who should ultimately clarify the scope of the statement of understanding. So this leads to a series of pressing questions. Should the Bengal rule be geographically unrestricted? We know that now we have an exception with Kenya, but what about the future? Should political boundaries influence geological assessment? How should dual method submissions be reconciled? And does this not call for the meeting of state parties to step in and clarify the rules? Who is here, the legislator? We don't have a legislator, we don't have an interpreter, it could be the courts. So let me conclude. The statement of understanding was designed as a regional fix, as I mentioned before, but it has grown into a flexible legal tool. It addresses inequities created by Article 76, but of course it is also generating new uncertainties. This practice of the CLCS has expanded its scope, but only international courts and tribunals and the states themselves can give it real legal clarity. So where do we stand today regarding this rule? The statement of understanding has been useful. It has given some states a way to argue for an extended continental shelf that they might otherwise have been denied. But it remains quite ambiguous. As I said, it is an exercise of interpretation of only 5 paragraphs, so a lot of work remains to be done. So if I make a play on words, so far so good, but a lot of legal work remains. Thank you very much.
Thank you, Dr. Angeles. In a lighter vein, I think you were 2 minutes ahead of schedule. So we'll archive these 2 minutes, and that will redound to your credit next time you go for any other conference. Well, can I just pick up a thread from what you just alluded to at the beginning? You refer to the role of international institutions in this paradigm. How do you see in terms of their effectiveness for these kind of mechanisms in real terms?
So thank you for the question and for the credit for the next conference. So I mentioned few institutions here. I mentioned the Commission on the Limit of the Continental Shelf, but as I said, this is a technical body. They cannot interpret, and they have been criticized for a long time regarding the guidelines for Article 76, so I feel it will be the same for the interpretation of the Statement of Understanding, because they will encounter the same problem. We will still have a technical body where there are no lawyers. It is only scientists, 21 scientists interpreting law. At the end of the day, the convention is law. The Statement of Understanding, it is in the final act, but it's still a legal, there are legal provisions. Then we have courts and tribunals. So, of course, you can reach the point where you take this to ITLOS or to ICJ or to arbitration, but you need a dispute having, like, in order to go there, you might say, okay, we need the court to interpret this. It might be the case, but again, it is so much relying on science that the court itself or ITLOS will still need experts to explain the science behind this. And then you have the state. At the end of the day, extending the continental shelf is a prerogative of the state. It is the state who decide if it will extend it or not, and how you do it. You have the commission just to monitor, to validate the limit. But it is the state's right to how to do it and to follow the rules. So of course there are many actors. I also mentioned here the SPLOS, the meeting of state parties, because these are topics that can be brought into stage, because there are more and more states interested. As I said, I decided to talk about this topic from my own experience. Like when we saw Kenya invoke a Statement of Understanding, we said, why not? Like if Kenya hadn't used it, I don't think it would have crossed our mind, because we have a Bay of Biscay, but it's not a Bay of Bengal.
Okay. Thank you for that exposition. I think we'll leave it there. May I now invite Dr. Manipathu Gandhi to kindly go ahead with this presentation. It's your discretion. Either you could do it in seat. You would wish to do that, or if you could, the choice is yours.
I'll do from here.
Sure. Feel free. Please feel free.
My presentation, you can take it a slight continuity of what has been done so far in the first presentation. Because if you, the delimitation part, especially the extended continental shelf, or you would say the outer limit of the continental shelf between opposing and adjacent states, that's the part that I'm going to deal with that. When it happens, what happens is, the assessment of CLCS, because CLCS just looked into whether that formula has applied properly. That's why no lawyers are there. Initially, I understand that there were first 2 elections, lawyers were there. Maybe lawyers would have been created a lot of problems for these people. Now, lawyers are not there in CLCS, okay? But what is the purpose for the CLCS? CLCS is very important today because CLCS and its assessment also taken into consideration when you go for adjudicatory forum. Now, what is the adjudication in delimitation of continental shelf beyond the limit, the 200 limit to the extended continental shelf limit, 200 nautical miles to 350, there are disputes. Now, so far in the continental shelf area, I know we have around more than 20 dispute resolution. And if you see the convention gives you some option that, either the parties to the unclause, they can select ICJ for the adjudication, or they may select ITLAS for adjudication, or they may select both ITLAS as well as ICJ for, the adjudication. If they are not mentioning anything about that, there is a default provision, that is the Chapter 7, the ad hoc tribunal. So this is the thing. Anyway, you can't escape from the adjudication because compulsory adjudication is a rule. So you can't do this. Now, what happens here is that there are 2 processes. Now, she was talking about one micro level where the Bay of Bengal, the south of Bay of Bengal should be interpreted only to mean within the Bay of Bengal, or it can be extended to endlessly south. But my understanding is the negotiators' record says that it should be interpreted in a very restrictive rule because it is an exception. But now it is gone to Kenya and other places. I really amazed the way the creativity that works. Anyway, that's a different issue. I don't want to get in that. Now, there are 2 issues involved in that. One is delineation, the other one is delimitation. CLC is supposed to look only about the delineation process. So why the CLCS is there? CLCS is there. I should not grab, by producing that kind of a map, some international area, continental shelf, international continental shelf area. So they have to see that by applying all the rules there, they want to see that you should not go beyond that, therefore, you freeze on that. So that is the idea. But the problem is, if you see that what the CLCS is doing, and it has a problem with states' approach to delimitation. Now, once she was explaining that. There are disagreements between the Commission on the Limits of the Continental Shelf and submitting coastal states. Very often they used to fight there. Addresses various issues arising from disagreement between CLCS and the submitting coastal state. In so doing, we have to appreciate the resilience of Law of the Sea Convention. Also, even though the CLCS has made some 40 recommendations so far to submitting coastal states regarding the outer limits of the continental shelf, only 12 of these recommendations have resulted in the establishment of final and binding limits under LOAC. So the finality needs to be set right by CLCS. It is meant for that. Because now you've drawn the map, it is final for you. But once that recommendation is given, who has to implement? It is only the coastal state has to implement. If you give 40 recommendations, only 12 states have agreed to it, then perhaps, it is a toothless body to start with. Then why the confusion has taken place? There have been multiple reasons for the disagreement, that such a test of opportunence, meaning of natural and submerged prolongation, the meaning of relevance of deep sea ocean floor, the priority of morphology over geology, the identification of the foot of the continental shelf. These are all the parts in the definition if you look. So in the identification of these constituent elements itself is in dispute. State says that it is this, and CL says that no, 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 we will not agree like this. So the determination of admissible landmass for applying 350 nautical mile distance constraint, the identification of then 2,500 meters isopath, because you come with almost all the data, they say that nothing is reflecting you have come with the 2,500 meters isopath. We don't agree. So the classification of seafloor highs, so-called bridging lines, and other potential issues of disagreement. Then in addition to that, the South China Sea, thing like that the status of islands, rocks, then when you just put it together, how it comes, then the statement of understanding that she was referring about the Bay of Bengal is one of the implement there. Whether it will be applicable only to that, the Bay of Bengal area, or it can be stretched out entire south towards that. So the coastal states are asserting excessive claims to the continental shelf would be no longer be the subject to an independent review because they finish it. That is a set up procedure where they say that we clear the map, all right, you have done well. Okay, it's one part. But your title to that area is not decided by CLCS. The title to the area is decided by the state. That should be, if any dispute is there, that should, the state should, jointly settle it, where the settlement process is there. And the settlement process, the coordinator mentioned that in the outset itself, what would be the settlement procedure. And the procedure is that in issue of overlapping EEZ and the continental shelf, if there is no overlapping, no dispute. If overlapping comes in, there is a dispute, right? Because, I read an interesting argument by a Japanese writer on, the continental shelf demarcation, the extended continental demarcation by East China Sea and Japan. And where the argument was very novel. Because you have this kind of a division and delimitation for that purpose, at least you must have 200 plus 400 nautical miles distance from one end to another end. Simple. They say, if it is from East China Sea to the Japan, if it is less than 400 nautical miles, where is the question of overlapping comes in? This is an interesting story. Then whatever the overlapping we are talking about that, and the fixed point is not there because it is lot of lacuna there, even when they drafted it. Because absolutely they have no idea about what they have been doing. They say that, all right, we have to push this draft. It has come to the final stage. If at all any difficulty is there, let them go to the tribunal, let the tribunal decides. Right? So politically, some decision should be taken for that purpose, for setting the map, and it is a correct map. They created CLCS, and in case of a title-related dispute comes in, you go to the tribunal. So this is the mechanism. They have originally done that. Now, how you have agreed on this? He was right that, this moderator, and he said that first measure is by agreement. India has settled its maritime zones, delimitation completely under 11 agreements with all our neighbors. 2 people left out, one is Pakistan, because Sar Creek is still pending. The another one is there, that is Bangladesh. Now Bangladesh, we have been negotiating for 4 decades. Nothing happened. Finally, they said that we are going to ITLAS, because we said that go. Whatever ITLAS says, we will consider. We will consider. When the ITLAS decision came in, and we said that, okay, it is in principle we agree, because that minor part is there, because the problem was, in fact, it goes to the tribunal like ITLAS. The actual CLCS map and other things, they will not consider at all. So that is separate thing. So with the result, what happens, whatever you submitted in CLCS, some portion is also cut. It so happens now, between Bangladesh and India, continental shelf, one state may have right in that particular area, a triangle area, And on EEZ, that side may not have right. It is very curious. Because, when you go for the exploration and exploitation of natural resources, and without touching the super adjacent water column, it is very difficult. Where will you go? You crawl there and do that? It's not possible. So sometimes, too many bodies, they are dealing with that. They may not have the integrity maintained. On the top of it, what happens is that they said, now, one is by agreement, and the second is by median line and equidistance line. These are all the jurisprudence developed by the tribunals, I'm telling. And there are over 220 decisions of tribunals, including ICJ, and they come with a standard formula that equidistance relevant circumstances rule and equidistance special circumstances rule. And all these true rules, how they applied in different situations, it is left to them. Because there is no objective criteria that has been revealed in their decision. Okay? So finally, they say that it is a three-stage delimitation, but we have gone beyond three-stage delimitation today. Because they say that first, establishment of a provisional delimitation line, methods based on methods that are geometrically objective and also appropriate for the geography of the area. In the geography of the area, only she was referring about that. Why that, the Bay of Bengal, as far, there is a very big curvature, then the sediments are just flowing, therefore it is special geography. But those who have negotiated with Bangladesh from Indian side, we know that India, they never opposed this kind of a thing. They originally projected in CLCS. They wanted to bring in their baseline just some 40 nautical miles from the coastline to interior to start with. Then why, on what basis you are asking? They come with a formula that, our sediments are so much thick, the water is very shallow, therefore, we can't use it for EEZ purposes, therefore we want to push it. We come with a fathom points, fathom hypothetical points. And all the points, it is something now fathom, it is again, completely on the basis of depth analysis. They put a hypothetical points, they link all these things, they say baseline is constructed. I said that it is interesting, but it is novel, and nowhere it is stated in the law of the sea this would happen. It went on for years and years and years. Finally, when they say that, all right, we have to submit there, we have to settle it, when, all right, you do it, let us see like that. This has happened. So, now, I have to finish it, I'm sorry. Now, so the continental shelf and exclusive economic zone, I have said that the three stage. Now the stage is also beyond that it has gone. I just mentioned only 4 points. After that, it will close. There is the jurisprudence, if you look for, the ITLAS jurisprudence moves in one direction, ICJ jurisprudence moves another direction. And both, they agree that there is no need for requirement of submission before the CLCS. But slight doubt exerted now. Now it says that ITLAS, especially in the Maldives case, they say that we will not consider into your extended continental shelf claim because you have never submitted anything new CLCS. It is left to me whether I submit that. That is a different process. Why should I submit? You decide. No, we have a feeling that you are not eligible to have that. This is what ITLA said. Another interesting, case that you know about, very often, we are talking about that. One is that, Nicaragua versus Colombia. It is a very interesting case. They say that when you demarcate delimit the continental shelf, extended continental shelf, you must see that it is not making inroads into 200 nautical miles of another state, they come. And this is the new thing. This is the new thing. So it is not the 3 stages. It is 4th stage, 5th stage, n number of stages, we don't know. So finally what happens, we are totally in the, jurisprudentially as a lawyer, you are under confusion and you have to work very hard to come with a new creativity like she said, all right, let me win the case, you know. So I will try to just put all the, whatever, the jurisprudentially legal points, and we constructed favorably. So that kind of a tactics that is adopted even today in all the delimitation cases. Thank you.
Thank you, Dr. Gandhi. I'm quite enthused that all my co-panelists are wrapping up prior to time. That's truly commendable. I have a question. Pardon me, I'm not a lawyer by qualification nor by practice, but the sense which I get, I mean, in terms of both your presentation, is that the entire architecture of the design of the mechanism that has been devised for all these resolutions, it truly lends itself to incredible complexity, enormous dilation in terms of time, and with no certain outcomes in a reasonable time horizon. Do we have to just live with it, you know? Do we lap it up and say we live with it?
We cannot live with that is why the tribunals.
Okay.
We passed an order, you say something on that. We leave it to the, we left it to the tribunals. Now tribunals, when the conflicting thing comes from the tribunal, because the tribunals never have a consistent viewpoint. Up to a point, they come consistent. Beyond that, there is no consistent. This is not like a municipal legal system where the doctrine of stare decisis will be applicable. They have to follow.
But so do they, just sorry to intervene,
Yeah.
do they not go by past precedents?
No, there is no need
Which
for
is
that.
singularly unfortunate.
Still, ideally, they have to maintain certain consistency. Then only there will be a predictability. You are a client, you are coming to me, what happens? I don't know, everything is left to the judge. He says that I'll see the judge, not you. So it is like that.
No, I just wanted to add that when the Article 76 was negotiated, they were not expecting that amount of claims. Like, I think they were expecting like around 30, and there are over 100. So that is also making all the delays, it is creating all these delays. Like, you submit and you have to wait for 10, 15 years before your submission is started to be considered.
So when do the verdicts attain finality? It could be a...
It will be finalized, you hinted that. Everything will be finalized finally, not necessarily on the basis of the decision rendered by them. After that, there will be a continuous negotiation. Because,
Okay.
earlier, we were the party, you take the standard lines, what are all observations, that observation will work.
All right.
In the negotiation, you can see that in most of the cases ICJ, after giving decision, and they will just reopen for negotiation. In the negotiation, they will settle it finally.
Okay.
So this is the final stage. If you are not going for that, there is no pressure upon parties.
I would have assumed that negotiation normally precedes litigation.
No,
But it's the other way around. But this is truly, I'm
it's
getting
not.
enlightened.
Negotiation proceeds.
Okay.
Negotiation succeeds. And finally it is settled.
With no offense meant, I think the lawyers have a field day in this. Okay, thank you so much. Now moving on, we have the final speaker. May I request Dr. Yusuke Honda to kindly go ahead with his presentation. Over to you. Would you prefer to use that? Please feel free.
Okay, namaskar. Good afternoon, everyone. After having lunch, as moderator Dr. Shetty said, that most of the speakers and most of the participants are now the time of siesta, but give me some more time for focusing on my presentation. Now, first of all, I would like to express my sincere gratitude to the conference convener for giving me this great opportunity. It is my great honor and privilege to be a part of distinguished speaker and moderator, and also the rapporteur. here. In my presentation, I will talk about how maritime boundaries will be affected or remain unchanged due to the sea level rise, with considering the relevant court decisions, including the recent developments such as climate change advisory opinion made by ICJ, and then find any legal implications for the Indian Ocean Rim and other regions. Okay, let's get started. Here's my outline of the presentations. The numbers are something strange, but anyway, I won't explain one by one, but anyway. So I will briefly explain the factual background with focusing on the Indian Ocean situation. The study shows that there are more than 400, or some say more than 600 potential maritime boundaries in the world, and less than half of that has been formally agreed by treaty or adjudication so far. Meaning that more than 200 or 300 parts of the boundaries remain undelimited. The percentage of unresolved maritime boundaries is particularly high in Africa and Asian regions due to the little administrative and scientific capacity, etc. And as mentioned elsewhere in the conference, in the first day and second day, and climate change is one of the greatest threats to the Indian Ocean Rim, and sea level rise is one of the consequences of climate change. A recent study shows that the project changes in the sea level of the Indian Ocean by the end of this century are between 46 centimeters to 76 centimeters with high confidence. This graph is borrowed by Indian researcher, published in 2023, I think, yes. And this is almost identical to the global mean projections by the IPCC. And cities such as Mumbai, Chennai, and Kolkata will be significantly affected due to sea level rise. This is a map borrowed by the Climate Central, the NGOs, showing if the sea level rose by 0.8 meters above high tide, 80 centimeters. In case of a high emission scenario, meaning almost the worst scenario, it seems that most of the coastal areas are not much affected, less than expected. But some of the areas highly likely to be affected by the rise in sea level, such as the western Bay of Bengal. The map indicates that the effect of sea level rise will occur asymmetrically. Next, I will quickly go through the related judicial decisions to find implications and confirm legal basis and principles regarding maritime boundaries, with focusing on the Indian Ocean situation. At present, several delimitation treaties have been concluded between and among Indian Ocean Rim countries, about 10, give or take. But most of the boundaries are established before entering into force of UNCLOS. So some of them are not based on the famous 2 or 3 stages approaches. And importantly, there are 4 cases regarding maritime boundary delimitation in the Indian Ocean. I know there's much of controversy in the decision itself and some of the implications mentioned by the previous speakers, but it is not the focus of my presentation. And also that there are de facto boundaries such as claimed by Kenya in Somalian Kenyan case, but ICJ didn't approve it. Although the Kenya deposited their Strait baseline boundaries to the UN. However, I checked a few days ago, but this coordinate has not been changed yet. And this map shows the treaty boundaries and the tacit agreement, the median line boundaries in the Indian Oceans. Here, the green line shows that median line, the de facto boundaries, and blue lines here, it's treaty boundaries. And this is the map shows that court ruling boundaries. As said, the 4 related decisions are rendered by various international court and tribunals, those boundaries are regarded as stable and final according to the UNCLOS, and also as confirmed by the famous Temple of Priya Behar case in 1961, I think. The stability of maritime boundary is derived from or ascertained by the principle of pacta sunt servanda, the Vienna Convention of the Law of Treaties, which means a treaty, and res judicata, court decisions, the ICJ statute says so, respectively. And these principles are subject to only limited exceptions, thus ensuring the stability of maritime boundaries. But more importantly, this stability also from the famous principles, land dominated the sea. Whether by the treaty or judicial process, the maritime boundaries are established based on the coastal geography at the time of delimitation. This principle was confirmed first in the Grisbadano case between Norway and Sweden in 1909, meaning more than 100 years ago, and also in the Bay of Bengal case, the Bangladesh and India case. The court confirmed whether the choice of base point located on the coastline and reflecting the general direction of the coast is feasible at the present time. Of course, defining or establishing baseline is a unilateral act, so that the recognition from other parties, other states, is not required to take effect. It is also confirmed by the famous court decision, fishery jurisdiction case. However, in the same case, the court says that the validity of the delimitation will depend on international law. So the opposability of the boundary and or baseline will be at stake. Based on this understanding, I will explain the possible effect of sea level rise on maritime boundaries. Before going into the details, it is of fundamental importance to understand the issue questioned in a legal sense, precisely. So I will describe what sea level rise means in a legal sense. What is the legal meaning of the sea level rise? And what is the impact of that? Sea level rise in a legal sense is a situation where the low water line in Article 5 of UNCLOS shift to the landward as a physical reality. So not only the normal baseline, but also straight baselines are also affected. As a result, maritime features may be inundated permanently. So the question is whether the state has an obligation to move baselines based on the physical reality of the coastline, or state can fix or freeze it, regardless of maritime features, even though it does not meet the criteria of the UNCLOS. The other question is, will this be the cause of triggering the principle of another principle, the fundamental change of circumstances, also known as rebus sic stantibus, on maritime boundaries? Here again, sea level rise occurs not uniformly, but varies elsewhere, and is unavoidable. The asymmetric effect of sea level rise will be the cause of legal dispute, such as if coastal areas or islands used as a reference point for maritime boundary delimitation become submerged, the current boundaries can be regarded as inequitable because of a cut-off effect by inundation. Now I'd like to show how sea level rise will affect maritime features in a legal sense using my PowerPoint animation I made. Here, if the sea level rise occurs, then those, I don't know why. Well, okay then. Next slide. Yes, if the sea level rise occurs, I don't know why, but something strange. Anyway, this is the end of animation. New low water line will be shifted to the landward. So then the question is, in that case, island or rocks will become low tide elevation, or low tide elevation as original stage become territorial sea, meaning that the ocean, or not. That is a problem. Actually, this is a completely fictional, hypothetical scenario. So then when sea level rise occurs, then the coastal line, as I said, the low water line will shift landward, so that the starting point of the will be changed. So that the the total area of territorial sea, easy and continental shelf will not likely be affected. And this map, yes, new map, this is a completely fictional and hypothetical scenario, so then I am not going to spark another dispute, so then please do not take offense. Meaning that if the sea level rose by 80 centimeters, as I said, the worst scenario, the relevant cost and area for the determining the boundaries in the Bay of Bengal case may be altered. I'm not sure whether this situation still meets equity as confirmed by the arbitration between two countries. Here. In my computers, something gradation has been reflected, but not yet reflected. But anyway, yes, this is a kind of the yes. As you see, the baseline has been shifted to the landward. So the relevant cost and the relevant area may be altered because of the sea level rise. For others in these situations, what will be required as confirmed above, land territory is source of maritime entitlement in the North Sea continental shelf. The court noted that land territory generates entitlement to maritime area. Then what would have happened to the boundary if the land had disappeared entirely, especially in case of island or low tide elevations? The impact is huge. Here are the important implications from the South China Sea arbitration in 2016. In its award, the court declared that UNCLOS requires that the status of the features be ascertained on the basis of its area, natural conditions prior to the onset of significant human modifications. And as a matter of law, human modification cannot change the status of maritime features. It means that once an island or land, always an island or land. But the low tide elevation cannot promote to the island, full-fledged island, by land reclamations. However, the problem is how to achieve equity in fluctuating boundaries under the effect of sea level rise. For the time constraint, I will quickly go through or just skip this slide. Here it's a recent development made by the ILC's final report of the study group on sea level rise in relation to international law. I have attended the final conclusion in Geneva this May. And also recently the ICJ delivered the climate change advisor opinion related to this, also including the implication regarding to the sea level rise. And here is the conclusion. In conclusion, against those findings and background, I can say the following observations. In the short-term outlook, no state had and will question the finality of the agreed or adjudicated maritime boundaries, notwithstanding the potential physical changes of coastline because of the sea level rise or anything. However, to stabilize the law of the baseline and delimitation against the adverse effect of sea level rise, I would like to propose to adopt General Assembly resolution, which can be regarded as subsequent agreement under the Vienna Convention of Law of Treaties. it will be the most effective and preferable to modify, de facto modify the lower baseline and delimitation under UNCLOS. End of my presentation. Thank you very much. This is the mascot character of my university's wild boar.
Thank you so much, Dr. Honda. I think I'm truly blessed to have a panel which all of them have closed well ahead of time. Just to the point, I was a bit curious when you said that there have been no instance where, if you can just go to the concluding slide, no instance where an agreed or adjudicated decision has been called into question. The last slide, if you could just kindly revert to that. Right at the top, it was the first bullet point in the conclusion portion. I think there is a line that no state has questioned the finality of an agreed or adjudicated maritime boundary. Would it be fair to say that this is universal? We have a glaring instance not too distant from our own backyard in the South China Sea. Would that not be an aberration?
Actually, I have no answer. It depends on the states.
Okay.
So far, no state who want to question on the current stage of the maritime boundaries because it will make another dispute, may lose their vested, already acquired the area of the maritime areas and also the maritime entitlement. So then including the sea, I don't know about the China's position on these issues, but so far the most of the low-lying small island states countries are hesitant to change the maritime boundaries because of the sea level rise.
So be it. I think I'll park that thought. Sorry, yes, Professor. Do you want to come up? Yeah, I'm coming to that. Yeah, for sure. Since we are on course to have about 20 minutes at hand before we wrap up, may I now invite the audience to please come up with questions. Please do raise your hands. This will be no particular order. I can see two ladies popping their hands up here. We can raise, you can probably flag a couple of more questions, and you do have, yes. I think, in all fairness, deferring to him, not because he's the organizer and the host, but I think he clearly raised his hand in the first instance. So over to you, Professor, and then we'll come to the ladies. And could you please identify to whom the question is intended?
Yeah, thank you.
That would be super helpful. Thank you.
Thank you, Mr. Shetty, and a really wonderful panel. Fantastic presentations. I really enjoyed everything. And I have good news for Dr. Anglis, because my recollection is that at the meeting of states parties in 2009, and I've just checked the report, that the meeting of states parties was of the view that where the same geographical circumstances applied as applied in the Bay of Bengal, that the statement of understanding could be applied. So I think that was the meeting of the view of the meeting of states parties. In addition to that, the United States has applied the statement of understanding in the context of their unilateral declaration of their continental shelf limits. However, I would always have thought that Dr. Gandhi's point is very relevant here, that if the statement of understanding is an exception, and by the way, there's, the history of the conference was, Sri Lanka was very late coming with this submission, and that's why it wasn't featured in Article 76. That, in international law, we tend to apply exceptions restrictively. And so, on the other hand, there's also the evolutionary nature of interpretation. So you've kind of two competing principles. But I would say that in terms of its application, there tends to be a liberal application of the rules by the Commission on the limits of the continental shelf. So, or should we say they have filled lacunae elsewhere. So I think, you know, this supports Spain's case. The second issue I'd like to raise, which was again addressed by Dr. Gandhi, but it came up on Mr. Honda's second last slide there, which was the currency of navigational charts. Because we have a very clear legal obligation under SOLAS Convention to update navigational charts. And that has been international law for very good reason, to do with the safety of navigation. So I was astounded when I saw the International Court and the climate advisory opinion stating that there wasn't an obligation to update navigational charts. Now, admittedly, in the context of fixing maritime limits in light of sea level rise. So maybe you could comment on that aspect. So thank you very much.
Thank you, Professor Ron. Your question about the obligation of updating the chart, that is also questioned during the discussion in the ILCs. But the point is the chart is chart for navigation or chart for baseline. That is a very much difference. So one of the members had questioned that if there is no obligation to update the chart itself, including the navigational ones and also the chart showing that they are baselines. If that is the case, as you said, that it will be the cause of the maritime accident. Because of the SOLAS Convention requires the vessel to update the recent situation of the coastal situations, and also reflecting the ECDIS, the electrical display in the vessels. However, the court does not mention about the obligation to update, including the nautical chart. Just mention about the chart related to the defining the baselines. So that's why this is completely different obligations. And also one of the point is that court just says there is no obligation to update. But if the reality has been changed hugely, there's how can I say? If those of the maritime feature has been originally such kind of the low tide elevation or some kind of shores, however, if the sea level rise give rise to all the maritime feature has been inundated, if that is the case, as visually they are the oceans, and then the vessel believe that this is the ocean, and then going through that areas, if that is the case, it can be some of the accident and maritime pollution will occur. So the ICJ does not say it is not obligation to update the chart or list of geographic coordinates, but have to meet the criteria of the UNCLOS, Article 5 or 16.7, etc. So then this is kind of the nuanced differences between the ILCs and also the climate change advisory opinion of the ICJ. This is my answer. Sorry for long my answers.
Thank you. I recall that there were two hands. Ma'am, if you don't mind, I think she raised it first.
1 minute.
Sure, please.
This is to clarify the professor. Professor, the annex, if you see the Trava properties of law of the sea, the proposal was Sri Lankan proposal. The Sri Lankan proposal, they made it very clear that they are disadvantageous geographically. Therefore, the law of the sea, by Annex A, they accommodated their claim, that's all. So it is restricted. Anyway, to start with, it was restricted. It should be really to be interpreted restrictively only. Because the reason was it is a specially accommodated Sri Lankan case because they don't have any continental shelf. They can't anywhere come near to the Indian side. That's why, you know, if they have to have the continental shelf, they have to go a long way and have circulated only from their west coast. If it is the east is there, their west coast, there is east coast. They have to go that side. Because this side is only very narrow. The distance between India and Sri Lanka, the length was about 17 nautical miles at one point. So geographically, they cannot have anything here. Can't. Then they say that they were crying. If that is the case, where we will go? We are disadvantages. Then you accommodate. Then you accommodate, the accommodation was on the basis of the proposal, Sri Lankan proposal. If you go back and see that, what had happened in the conference, and people will come to know that it is a Sri Lankan proposal, only accommodate Sri Lanka, this has been done. This has been taken up in our negotiation many times, been brought to the notice. Thank you.
May I now invite you, ma'am, please go ahead. Following that, it's your turn.
Thank you to all the speakers for the insightful presentation. I'm Dominic. I'm with the Indonesian Ministry of Foreign Affairs in the Directorate for Legal Affairs and Territorial Treaty. So this is our job in delimiting maritime boundaries. And we have 10 bordering states, so it's a long process of delimitation. This topic is very timely for Indonesia specifically because as legal advisors, we can learn a lot from your presentations. I have very short questions to the speakers. The first one is probably for Professor Honda with regard to the principle of land dominates the sea that you mentioned in the North Sea continental shelf. I'm aware that the North Sea case was adjudicated before UNCLOS was entered into force. So I'm not sure if the principle of land dominates the sea is still applicable because it's distance-based now in UNCLOS, especially as Indonesia is employing archipelagic baseline, so it doesn't necessarily be in line with the land dominates the sea principle. The second question for any speaker who is willing to answer is regarding the applicability and the interplay between the 58 conventions and UNCLOS. So as some speakers mentioned that some delimited boundaries have been agreed before UNCLOS, what if, for example, the Continental Shelf Agreement is inequitable if we look at it based on UNCLOS provision? This happens to Indonesia. We have 69 agreements with Malaysia on continental shelf, but then we also try to assess how it may affect Indonesia's interest in light of the 1982 UNCLOS. And last one, I'm sorry if it's a lot. The last question was with regard to the different approach, not ICJ and ITLOS, but PCA and ITLOS. If I'm not mistaken, there is a different approach in the use of archipelagic baselines by the arbitral tribunal in PCA, in the case of Barbados versus Trinidad and Tobago, and also in ITLOS in the case of Mauritius versus Maldives. I'm not sure if the speakers are aware, but I just want your thoughts on this matter. Thank you.
So we'll distribute it equitably. The first poser is for Dr. Honda, and the remaining two, I'll farm it out to each one of them.
Okay, thank you. Okay, thank you very much for the questions. And I would like to answer the first question, whether the land dominated sea principle still applicable in the present case, present and ongoing case. And the short answer is yes, because this is just a principle recognized in the international court and tribunals. And the recent case, the land and maritime delimitation and the sovereignty over islands between Gabon and Equatorial Guinea case, it's rendered in this year's May, I think, yes. And then in this judgment, the court says that the principle of the land dominated sea also mentioned, yes, the court mentioned that, does not automatically assign coastal states right to specific maritime areas, meaning that although this principle is very much important for the confirming the maritime entitlement, but principle itself does not generate any maritime entitlement. This is just a principle. So then, of course, it depends on the judges ultimately, but the principle is still applicable. Yes. So then it totally depends on you, your government, how to utilize this principle for your interest. Thank you.
So please take your pick and go for it.
Yeah, I will start thanking Professor Lom for his comments before. I feel that the change in the approach of the Venga rule is there were many states submitting submissions in 2009 because it was the deadline and states didn't know what others were doing. So Kenya submitted, including the Statement of Understanding, but nobody realized, like at that time, it was forgotten for a long time, and then the moment it started to be considered, it when it rang a bell and the state starting to be alert, like we may use this. That was our case. And we can even review what we have submitted, or we can, for the new state submitting in the future, that might be a possibility. UNCLOS and the submissions, the guidelines refer to the Statement of Understanding. So it is a possibility that it was always there, but the state, I think they were interpreting the step themselves restrictively, considering that it was something for the Bay of Bengal. But yeah, since the issue here is inequity, it can be anywhere. So I think that will open the door in the future for more states, like as I mentioned, like more states might experiment with it. And it was surprising that India didn't use it, but it reserved its right to do it in the future. So it was not, at the time of submitting, it was not in vogue, but they reserved the right to do it in the future. And answering Ms. Virgil's question, the 1958 convention had a clear rule for delimitation. It said that it must be based on equidistance. And now in UNCLOS, we don't really have a rule for delimitation. We know that we need to reach an equitable solution. So how to balance that? Because we know we are bound by our own agreement. There is always a possibility to denounce if you consider that this is not equitable. But at the end of the day, what's the position of the other state? Because I feel we have the same situation. We negotiated our delimitation agreement in the Cantabric Sea with France in 1974, before UNCLOS, and at a very bad time for us, and we agreed on something that is not fair at all. And when we see the map today, we see that it is not equitable. It is not even equidistance. It was our own negotiation. So there is always that chance, otherwise, but it's not that the new convention changed the rules. It is like there is no rule today. It is the interpretation of the case law interpretation. Thank you.
You know, I agree with both of them, because the principle you said that, the land and sea connection, that is not only there, it is reiterated again and again in many judicial decisions. And secondly, you are asking about the continental shelf, the delimitation part. He has given a right answer. If you still want to trace back, all originated not only in the convention, it originated in 24th September 1945 Truman Declaration. I think it is the 4th paragraph or 5th paragraph. Truman Declaration says that has exactly taken and put it in the convention. If you revisit, where the equitable position, that equity also mentioned, and there was also the reference about how we should go on when he declares about continental shelf. So there is a clear line of thinking, and that is continuously coming, concretized into the rule. That rule is almost a fundamental rule today. So we can't say that, you can alter it. You have to alter it, you have to find some other new way, new innovation. Not telling that, the dateline and other things. Thank you.
Hope that answers all your questions. Thank you. Ma'am, the floor is yours.
Thank you very much. I joined the crowd. Fantastic presentations. My question is for Dr. Jimenez. You talk about the extended continental shelf claims and the legal creativity that is being used. Do you foresee any type of risks if states continue to rely on legal creativity in their claims in the extended continental shelf? Thank you.
Thank you very much for your question. So, yeah, of course, there are risks, not only for the extended continental shelf, but any exercise of creativity may entail some risk. So of course here it would be the legal uncertainty, like there won't be predictability. We see what others are doing and we rely on what others are doing and try to follow, but here, if we just rely on creativity, it will be more difficult to predict. And also that will stretch the treaty beyond what was originally negotiated. So it is also the exercise of interpretation of a treaty beyond what was negotiated. Then there will be a fragmentation in practice, like like each state will, maybe there is no consistent practice between states, and that could lead to a patchwork of approaches in interpreting, in this case, the extended continental shelf. There will be more political tensions because there might be overlaps that were not there at the beginning, like overlap that were not considered because the way we were interpreting the rules didn't lead to an overlap. And in the case of the continental shelf, it will also extend. Yeah, the Commission on the limits of the continental shelf will go beyond its mandate if it is supposed to accommodate the new strategies or the new creative rules. So it is good for innovation, it is good for flexibility on the way we apply the rules, but it's also, it also undermines the stability that we are looking for in the, at least in the process of delimitation, of the delineation. Thank you.
Thank you. I think for want of time, we're just on the cusp of closing. I'm afraid I may have to apply the guillotine here, but before I draw it to the close, I have just one single, and I'm tempted to make this, and I just, by way of a reiteration, this is all very well when we look at from a mechanistic, technical jurisprudence point of view. You determine, delimit all that you want, but fundamentally when it comes to execution and implementation, the world is a very, very different place. And I am absolutely fond, I have this penchant of bringing up the Somali example. In their own sovereign backyard, literally the world played havoc in dumping toxic waste and also in terms of IUUF. And we have paid, the world has paid a humongous collateral price for that over a period of time. Leave aside, I mean, I can just give you an example. Almost $150 million of ransoms paid, and I was privy to that in a sense, directly and indirectly, year on year in Somalia between 2009 to 2012, staggering amounts paid out. That's only one component of the story. The exponential expenditure on the naval forces which were deployed, I don't think it's even probably even empirically calculated. And I will leave it to your imagination as to what it is. So the fundamental point that I would like to leave for a thought for you is that the implementation and execution of all that we determine here, I think that's a gray zone, and which is where we need to put our heads together and see why. I mean, again, come back to Somalia. It's a failed state since 1991. And dare I say that even now, it's probably as fragile as it was back then. And piracy is just sort of been contained, but the causative factors still remain. So with that, I will draw to a close. I would like to extend my personal warm gratitude to all my three co-panelists for very insightful and illuminating presentations. Truly, it's been a delight for me to have steered and navigated these conversations around, and I hope you've enjoyed it as much as I did. Thank you once again. Thank you. And I'm on dot of time at 3:40.
A heartfelt thank you to our moderator, Mr. Deepak Shetty, for expertly guiding today's discussion. We are also deeply grateful to our distinguished panel of speakers. We now invite Dr. Tafsir Martin Johansson, the Associate Professor of World Maritime University, to felicitate the delegates. Mr. Deepak Shetty, the moderator for this session, Dr. Angeles Jimenez Gracia Carriazo. Dr. Manimuthu Gandhi. Professor Yusuke Honda. I also welcome and invite the rapporteur for this session, Ms. Fabriani Sabatira. Ladies and gentlemen, we will now take a short refreshment break. We humbly request you to rejoin us promptly so that we may continue with the next session on schedule. Thank you all. please do collect the certificate of attendance from the registration desk. Thank you.